And then you get a letter, and the letter says, if you don't give me the easement, we're going to apply to the Supreme Court. We actually don't represent developers. I know property prices in Sydney. There is no way that this valuation could be right. We were able to stave off the developer. I'm going to tell you a story. This is something that happened to a client of mine. Okay, picture this. You're sitting at home, minding your own business, relaxing, maybe watching a little bit of TV. You hear a knock at the door. It's a developer. He says, I'm doing a development next door and I need an easement over your property. Sounds reasonable perhaps, the person's very friendly. Seems like it's something that's worth considering, you don't really know much about it. You ask for a bit more information, you don't hear anything back for a while. A little while later they come back, talk to you again, and this happens a few times, okay? This happens a few times. Then it starts to become a bit real. They say to you, I need this easement, this is what it means. You do a bit of your own research and you start to think, I don't know if I really want this or what this really means for me. And then you get a letter, and the letter says, if you don't give me the easement, we're going to apply to the Supreme Court and make the Supreme Court give it to you by virtue of something called Section 88K of the Conveyancing Act. And they also attach some kind of lowball valuation, which tells you that the compensation that you'll be entitled to is some very minor sum. You're thinking, I know property prices in Sydney. There is no way that this valuation could be right. At the same time, I've been given this big stick, which is this court case. What does that mean for me? Am I going to have to pay a lot of legal fees? Am I going to win this case? Do I lose the rights over my land? Are they going to be able to come and do what they want? Surely people can't just come in and say, I'm going to use your property even though you don't want me to, without paying for it. Surely not. These are the types of things that you'd be thinking. So picture this. Now they start to put a bit more pressure on you with this, and you think, I really have to do something about it. Now in this scenario, it went full extreme. They actually started the court case as well. So now you've been served with the document, you have to turn up to the Supreme Court. What are you going to do? Now the story has a good ending if you're on the side of the character we're talking about, which is the poor person who's been asked for the easement. In the end, in this case, we ended up winning. I'm going to tell you the story of how that unfolded. And that might help you if you're in the same situation, or if somebody's actually asking you for an easement as well, so you can sort of map out what to do. Basically, and I've been doing this for a while, I'm a lawyer, we've been doing this for the last 8 years or so. It follows the exact same pattern. And one of the things that we do in our practice is we actually don't represent developers. I think that that's a bit more of a corrupting influence, because what happens is when you represent developers, you want to get more developer money, and so you can't really put your all into defending the ordinary person. It's generally viewed that there's not, a whole lot of money available if you're working for the ordinary person, whereas you can build a massive practice out of working for developers. So let me go through what happened and how this works. Now, in our case, it went straight to court, and we ended up winning. During the court cases we were preparing, we tried to look for examples of people who've won in similar cases, and there's just very, very few out there. So this one, they asked for a stormwater easement, and that's one of the very common ones that are asked for. So let me go through what the rules actually are, because I think the first thing that happens is you have to figure out, well, where do I stand here? Do I actually have to give this easement? Do I really have to accept this compensation? Am I going to get slammed with legal fees? What's going to happen to me? What's the stress that I'm going to be under? All of these types of things. These developers, they do a lot of these. They deal with people every day, and they're used to it. You're just another one of those. Whereas for you, it's a really big deal. This is your house. So I'm going to go through the 5 parts of 88K, okay? And I'll explain them by reference to this story. as well to just make it a bit more understandable. The first part is you have to have the easement being reasonably necessary for the development of the land. That means that the developer needs to say to the court, look, if I don't get this easement, I cannot develop this land. It's going to stay as it is. If it's a dump, it's going to stay as a dump. If it's a one small house, it's going to stay as a small house. I cannot do anything on this land without getting this easement. Now, an easement is basically some sort of right over your land. So it might be something like this. They'll look at the water flow and they'll say, look, the land slopes in such a way that your land is sort of at the bottom, and that means there's going to be water and it's going to need to drain through your land. So we're going to need to put some pipe work in your land. That's an easement. It gives someone a right to use some of your land, like a defined part of your land, for a particular purpose, such as draining stormwater, or it could be for electricity cables or services, or for anything really. It's something like that. Even driving over it, walking through it, that these are all easements. So they have to. So that's the first part, and they were able to say, well, the reason it's reasonably necessary in this case is they actually went to the council, got a DA, the council approved it without a lot of consultation, which was unsatisfactory. They just approved it and said, well, the council requires it. That's why it's reasonably necessary. The second part is the public interest test. Okay, now the public interest test works like this. It has to be not inconsistent with the public interest. Now, when the council gives approval, it's considered, generally speaking, to be in the public interest because the council, who's representing the public in the area, says that it needs to be done. So usually the council approval will tick that box, and they had that in this case. The third one is that you have to make all reasonable attempts to negotiate for the easement or an easement of similar effect. Okay? Now, this is an interesting one because by law, and this is very pro-developer, the all reasonable attempts test can be met at any time. It's not like you have to negotiate first and go, this is going nowhere, and only now can I apply to the court. You can apply to the court on day one, before you even contacted the other person, as long as you do some sort of negotiation before the final hearing. And court cases take a long time. It can take a year. Sometimes it takes longer before it goes to a hearing. So sometimes what a developer will do is they'll say, I'll just file this now in the courts, start the court case, and then at least I've got a 12-month window, maybe 18 months before it's decided, and they usually think that they're going to win and I'm going to get my easement. So there's that category. Now in this case, that category was a bit of a stickler because one of the things you have to do is you have to make reasonable attempts to find an easement of a similar effect. That means that maybe they could have done something else. They could get an easement or get an easement somewhere else or do something slightly different, and they'd be able to still do their development. And that's one of the key requirements. So in this case, they actually hadn't done that because they jumped the gun really fast. And they could have tried to do that, up until the hearing, but they didn't. And that's actually one of the things that helped us. Then there's compensation. Okay, that's the fourth thing. Now, I mentioned before how the compensation figure was ridiculously low with the valuation, and that's common. What usually happens, and I've seen this happen again and again and again, is someone gets a valuer, and the valuer does this beautiful report, and the report says, and it's got all this explanation there, and the report says that the value of the property in the easement is some ridiculously low figure. $5,000, it might be $7,000, it's something low. And then what they do is they write to you and they say, look, I'm being reasonable, I'm going to offer you $10,000, which is more than this valuation. And by the way, if I go to court and I need to do an 88K application, I'm going to tell the court that I offered you more than it's worth and you said no, and I'm going to try to get you to pay my legal fees. So there's a bit of that threat there, the legal fees threat. You're thinking, not only will I have to give this easement, not only will I only get $7,000, but I'm going to have to pay who knows how much in legal fees. And legal fees are usually seen to be pretty expensive, right? Is it going to be 50,000, 100,000, 200,000? These things are worrying, so it puts a lot of pressure. So the compensation actually doesn't work that way. It's worth at this point just actually explaining how it actually works. In that case, they didn't follow the method that you're supposed to follow to do valuations. And when it came to the court case, they actually had to get a new valuer with a new valuation, which just goes to show a lot of the first valuations that are done are very low-ball valuations. They're not done properly. Generally speaking, if you're looking for valuation to be done correctly, you're looking for 5 things. Whether they address like blot on title, they address loss of proprietary rights, they address associated costs to the owner, it addresses compensation for insecurity and loss of amenity, and compensates for disturbance. It's basically a compensation for losses, and so usually the valuation has to take those things into account. So if you get given a valuation that's sort of like covering, errant other things, you can probably go, well, maybe this valuation isn't quite right. You can sort of push back on it. And the 5th thing is legal costs, which I just mentioned now. The rule is that even if the developer wins the court case, generally speaking, they'll still have to pay your legal fees. Now, that's contrary to the rule most people understand. Most people think if someone starts a court case and that person wins, they win the legal fees as well. And the loser has to pay the legal fees. And that's usually the case. But in 88K, it's not like that. Usually, it's the person who's applying for the easement who'll have to pay the legal fees. It is exceptionally rare that the person who is being asked for the easement, this is the ordinary person, has to pay the legal fees of the developer. It would be a very unusual situation for that to occur. Obviously, that risk is always there, but it's just an extremely rare situation. So, what do you do in these types of situations? Well, I think the key with this and the way the legislation is drafted is negotiation, because it is drafted in a way that's somewhat pro-development, okay? To have a rule with only these boxes that I mentioned to tick, they don't seem to be very complicated boxes, right? So negotiation is the key. And in all of these ones, we settle most of them, pretty much all of them in some way that's favorable to everybody. But the most important thing is you have to know what outcome you want. Do you want to be giving an easement at all? If you do, are you looking to maximize compensation? Are you more worried about where the easement will go? Are you more worried about the terms, how often someone can come onto your property, the damage that it could cause? You got to have a pretty clear picture of what your end goal is, okay? Because without that, you can't really do a lot, because your entire strategy will be based on that. If once they start this, you're sort of in the game. You don't want to play the game, but you're in the game. And you have to say, well, what do I want as an outcome? And if you don't have an outcome, then it'll just get dictated by what the developer wants, because they have a particular view in mind and you don't have anything. You have no strategy. So you need to be very smart and very clear. And then you have to think, well, what am I going to do to be able to achieve the goal that I want? And we work together. Is this going to be a combative situation? All of those types of things. So before you negotiate, of course, I think you just have to know where you stand. What is my position at law? Is the court going to give me something better, or are they going to give me something worse? Am I in a strong position, a weak position? These types of things are very important, because then you know where you stand, and then you're able to, negotiate accordingly. So hopefully that's been interesting to you. In our case, of course, it was a victory for us. We were able to stave off the developer. for various reasons, and so it is possible to do. It doesn't happen very often. It happened for us. And it can happen for you as well. I mean, there's no reason for you to not stand up for your rights or what it is that you're looking to achieve. Because if you follow the right roadmap, the law is there to help everybody kind of come to a solution that works the best for everybody, if possible. Okay? So, if you are in this kind of situation, if you want to give us a bell, contact us. We'd be happy to help you out.